hisuyayo. Opawaje, Saptan, Chonche.
Hey everybody, welcome back to A People's Historian, the show where we read about half an hour of history together. My name is Jason Kishinev and we are reading An Indigenous People's History of the United States by Roxanne Dunbar Ortiz. This episode will start chapter 11. We are getting along in the book, getting close to finishing. A couple more chapters. If you like the show, please hit the like and subscribe button and that notification bell so you get notified when I make new videos. Let's dig in. Chapter 11, The Doctrine of Discovery. And again, it starts off with two quotations. The whip covers the fault by Darcy McNichol, The Surrounded. I'm not sure if that's a book or a poem or what. Native liberty, natural reason, and survivance are concepts that originate in narratives, not in the mandates of monarchies, papacies, severe traditions, or federal policies. Gerald Visner, The White Earth Nation. In 1982, the government of Spain and the Holy See, the Vatican, which is a non-voting state member of the United Nations, proposed to the United Nations General Assembly that the year 1992 be celebrated in the United Nations as an encounter between Europe and the peoples of the Americas, with Europeans bearing the gifts of civilization and Christianity to the indigenous peoples. You couldn't make that up, right? To the shock of the North Atlantic states that supported Spain's resolution, including the United States and Canada, the entire African delegation walked out of the meeting and returned with an impassioned statement condemning a proposal to celebrate colonialism in the United Nations, which was established for the purpose of ending colonialism. The doctrine of discovery had reared its head in the wrong place. The resolution was dead, but it was not the end of efforts by Spain, the Vatican, and others in the West to make the quincentennial a cause for celebration. Only 5 years before the debacle in the UN General Assembly, the Indigenous Peoples of the Americas Conference at the UN's Geneva headquarters had proposed that 1992 be made the UN Year of Mourning for the onset of colonialism, African slavery, and genocide against the indigenous peoples of the Americas, and that October 12th be designated as the UN International Day of the World's Indigenous Peoples. As the time drew near to the quincentennial, Spain took the lead in fighting the indigenous proposals. Spain and the Vatican also spent years and huge sums of money preparing for their own celebration of Columbus, enlisting the help of all of the countries of Latin America except Cuba, which refused, and paid for this in withdrawn Spanish financial investments. In the United States, George Herbert Walker Bush administration, cooperated with the project and produced its own series of events. In the end, compromise won at the United Nations. Indigenous peoples garnered a decade for the world's indigenous peoples. Indigenous peoples garnered, a decade for the world's indigenous peoples, which officially began in 1994. I never even heard of it. but was inaugurated at UN headquarters in New York in December 1992. August 9th, not October 12th, was designated as the annual UN International Day for the World's Indigenous Peoples, and the Nobel Peace Prize went to Guatemalan Mayan leader Rigoberta Menchú, announced in Oslo on October 12, 1992, a decision that infuriated the Spanish government and the Vatican. The organized celebrations of Columbus flopped, thanks to multiple highly visible protests by indigenous peoples and their allies. Particularly, support grew for the work of indigenous peoples at the United Nations to develop new international law standards. According to the centuries-old doctrine of discovery, European nations acquired title to the lands they discovered, and indigenous inhabitants lost their natural right to that land after Europeans had arrived and claimed it. Under this legal cover for theft, Euro-American wars of conquest and settler colonialism devastated indigenous nations and communities, ripping their territories away from them and transforming the land into private property, real estate. Most of that land ended up in the hands of land speculators and agribusiness operators, many of which, up to the mid-19th century, were plantations worked by another form of private property, enslaved Africans. Arcane as it may seem, the doctrine remains the basis for federal laws still in effect that control indigenous peoples' lives and destinies, even their histories, by distorting them. The whip of colonialism. From the mid-15th century to the mid-20th century, most of the non-European world was colonized under the doctrine of discovery, one of the first principles of international law Christian European monarchies promulgated to legitimize investigating, mapping, and claiming lands belonging to peoples outside Europe. It originated in a papal bull issued in 1455 that permitted the Portuguese monarchy to seize West Africa. Following Columbus's infamous exploratory voyage in 1492, sponsored by the King and Queen of the infant Spanish state, another papal bull extended similar permission to Spain. Disputes between the Portuguese and Spanish monarchies led to the papal-initiated Treaty of Tordesillas, 1494, which, besides dividing the globe equally between the two Iberian empires, clarified that only non-Christian lands fell under the discovery doctrine. The doctrine on which all European states relied thus originated with the arbitrary and unilateral establishment of the Iberian monarchies' exclusive rights under Christian canon law to colonize foreign peoples. And this right was later seized by other European monarchical colonizing projects. The French Republic used this legalistic instrument for its 19th and 20th century settler colonialist projects, as did the newly independent United States when it continued the colonization of North America begun by the British. In 1792, not long after the U.S. founding, Secretary of State Thomas Jefferson claimed that the doctrine of discovery developed by European states was international law applicable to the new U.S. government as well. In 1823, the U.S. Supreme Court issued its decision in Johnson v. McIntosh. Writing for the majority, Chief Justice John Marshall held that the doctrine of discovery had been an established principle of European law and of English law in effect in Britain's North American colonies, and was also the law of the United States. The court defined the exclusive property rights that a European country acquired by dint of discovery. Discovery gave title to the government by whose subjects or by whose authority it was made against all other European governments, which title might be consummated by possession. Therefore, European and Euro-American discoverers had gained real property rights in the lands of indigenous peoples by merely planting a flag. Indigenous rights were, in the court's words, in no instance entirely disregarded, but were necessarily, to a considerable extent, impaired. The court further held that indigenous rights to complete sovereignty as independent nations were necessarily diminished. Indigenous people could continue to live on the land, but title resided with the discovering power, the United States. A later decision concluded that native nations were domestic dependent nations. Can't you just see it in the court saying, well, since the Americans, the white men, discovered this land, they own it. So I'm sorry, you can't be your own country because they discovered it. And so then the indigenous people are like, discovered it, but we were already here. And the judge says, no, they discovered it. The doctrine of discovery is so taken for granted that it is rarely mentioned in historical or legal texts published in the Americas. The UN Permanent Forum on Indigenous Peoples, which meets annually for 2 weeks, devoted its entire 2012 session to the doctrine. 3 decades earlier, as indigenous peoples of the Americas began asserting their presence in the UN human rights system, they had proposed such a conference and study. The World Council of Churches, the Unitarian Universalist Church, the Episcopal Church, and other Protestant religious institutions responding to demands from indigenous peoples have made statements disassociating themselves from the doctrine of discovery. The New York Society of Friends, Quakers, in denying the legitimacy of the doctrine, asserted in 2012 that it clearly still has the force of law today and is not simply a medieval relic. The Quakers pointed out that the United States rationalizes its claims to sovereignty over native nations. For instance, in the 2005 U.S. Supreme Court case, City of Sherrill v. Oneida Nation of Indians, the statement asserts, "We cannot accept that the doctrine of discovery was ever a true authority for the forced takings of land and the enslavement of or extermination of peoples." The Unitarian Universalist Association resolution regarding this in particularly powerful and excellent model, the UUA, and this is a quotation, repudiates the doctrine of discovery as a relic of colonialism, feudalism, and religious, cultural, and racial biases having no place in the modern-day treatment of indigenous peoples. End quotation. The Unitarians resolved to, another quotation, expose the historical reality and impact of the doctrine of discovery and eliminate its presence in the contemporary policies, programs, theologies, and structures of Unitarian Universalism. and invite indigenous partners to a process of honor and healing, often called truth and reconciliation. End quote. They additionally encouraged other religious bodies to reject the use of the doctrine of discovery to dominate indigenous peoples, and resolved to collaborate with groups to propose a specific congressional resolution to repudiate this doctrine and call upon the United States to fully implement the standards of the UN Declaration on the Rights of Indigenous Peoples in the U.S. law and policy without qualifications. Tangled contradictions. U.S. officials get tangled in the contradictions inherent in the attempt to legitimize empire building through the doctrine of discovery and the origin story of making a clear break from the British Empire. The rhetoric is often baffling, particularly when it references U.S. American cultural memory of the wars against native nations, as it did following the declaration of the War on Terror after the terrorist attacks of September 11th, 2001. In early 2011, a Yemeni citizen, Ali Hamza al-Bahlul, was serving a life sentence at Guantanamo as an enemy combatant. A military tribunal having convicted him of crimes associated with his service to Al-Qaeda as Osama bin Laden's media secretary. The Center for Constitutional Rights, or CCR, issued a statement prior to the hearing in the appeal of Bahlul's conviction. In arguing that Bahlul's conviction be upheld, a Pentagon lawyer, Navy Captain Edward S. White, relied on a precedent from an 1818 tribunal. In his 37-page military commission's brief, Captain White wrote, "Not only was the Seminole belligerency unlawful, but much like modern-day Al-Qaeda, the very way in which the Seminoles waged war against U.S. targets itself violate the customs and usages of war." Don't get me started. The CCR objected to this passage in the government's brief. The court should reject the government's notable reliance on the Seminole Wars of the 1800s, a genocide that led to the Trail of Tears, the CCR declared. The government's characterization of Native American resistance to the United States as much like modern-day Al-Qaeda is not only factually wrong, but overtly racist, and cannot present any legitimate legal basis to uphold Mr. Bahlul's conviction. In response, the Pentagon's General Counsel issued a letter stating that the U.S. government stood by its precedent. I don't think I understand it. Are they utilizing the doctrine of discovery, saying that because Al-Qaeda is not Christian, they have the right to say they discovered their land? Could be. This is America. We wish to continue to exist. The question of self-determination of peoples is a recent historical phenomenon integral both to the formation of modern European nation-states and to the gradual formation of an imperialist world system, eventually led by the United States. National integration and state formation occurred first in Western Europe as its states established colonies and colonial regimes in Africa, Asia, the Pacific, the Americas, and the Caribbean, and as the United States established itself as an independent state. These conquests afforded European states and the United States access to vast resources and labor that in turn allowed them to industrialize and to create efficient bureaucratic structures and political republicanism. Yeah, it says that because it's a republic. She doesn't mean the political party. At the end of this process, with decolonization of European holdings in the 20th century, self-determination became a major global issue, eventually incorporating all human beings as citizens of nation-states. The creation of nation-states and the redrawing of national boundaries that this often entailed inevitably raised the questions of which national, ethnic, religious, and linguistic communities were included and whether their consent or participation would be required. There are peoples and nations without their own states, locked under a state authority that may or may not be willing to respond to their demands for autonomy within the existing state. There sure are. If the state is not willing, the peoples or nations may choose to insist on independence. That is the work of self-determination. In the United States, indigenous nations that seek political autonomy or even independence engage in nation building. That is, developing indigenous governance and an economic base. For decades, Native activists and organizers in North America have worked tirelessly to establish the validity of treaties and to foster and protect the self-determination and sovereignty of indigenous nations. The nations seek control of their social and political institutions without compromising what they consider unique and essential cultural values. The cultural concern for indigenous peoples in the United States is prevailing upon the federal government to honor hundreds of treaties and other agreements concluded between the United States and indigenous nations, as between two sovereign states. Demands to have treaties and agreements upheld have never abated, and they have accelerated since the end of the termination era. However, the indigenous concept of nation and sovereignty is quite distinct from the Western model of the state as the final arbiter of decision making based on police enforcement. Rather, as indigenous lawyer and activist Sharon Venny has put it, sorry if I mispronounced that, as usual, we know the laws given to us by the Creator. It is an obligation. It is a duty. It is the future of our children's children. We cannot, like the non-indigenous people who make rules and regulations and change them when they don't like the rule or regulation. We were given the laws by the Creator. We have to live the laws. This is sovereignty of indigenous people. Americans change laws because we don't like them? Following the 1973 standoff at Wounded Knee, the American Indian movement brought together more than 5,000 indigenous representatives, including ones from Latin America and the Pacific, in a 10-day gathering that founded the International Indian Treaty Council, IITC, which then applied for and received UN non-governmental consultative status in 1975. The IITC proceeded to organize the first conference to be held at the United Nations on Indigenous Peoples of the Americas in 1977. At this conference, Northern Cheyenne tribal judge Marie Sanchez opened the proceedings. Members of this conference, delegates, and my brothers and sisters who are present here today, we are the target for the total final extermination of us as a people. Us as people. The question I would like to bring forth to this conference, to the delegates from other countries here present, is why have you not recognized us as sovereign people before? Why did we have to travel this distance to come to you? Had you not thought that the United States government, in its deliberate and systematic attempt to suppress us, had you not thought that that was the reason they did not want to recognize us as sovereign people? The only positive thing that I feel should come out of this conference, if you are going to include us as part of the international family, is for you to recognize us, for you to give us this recognition. Only with that can we continue to live as completely sovereign people. And you also, because you are part of the family of this world, you should also be very concerned, because the common enemy is your enemy too. And that enemy dictates policy to your governments also. I warn you not to be so dependent on the country that we are under, on the government that we are under. We have demonstrated to you how many hundreds of years we have survived. We wish to continue to exist. The international work at the United Nations grew slowly at first, but by the mid-1980s it was attracting grassroots indigenous representatives from around the world and constructing important initiatives. The global indigenous cause reached a major milestone in 2007 when the UN General Assembly passed the Declaration on the Rights of Indigenous Peoples. Only 4 members of the Assembly voted in opposition. All of them Anglo-settler states: the United States, Canada, New Zealand, and Australia. All 4, with some embarrassment, later changed their votes to approval. Leo Killsback reflects the perceptions of most native people that the Declaration might bring Western cultures out of their old world of savagery and closer to humanity, noting the example of the end of World War II. After the fall of Nazi Germany, its leaders were publicly ostracized, tried, convicted, and executed for war crimes at the Nuremberg trials. This led to the Genocide Convention and the Universal Declaration of Human Rights. Nazi Society members affirmed that the Holocaust occurred, and some were forced to visit concentration camps only feet from their place of residence. Under Truth and Reconciliation, German society began to rebuild itself, and with the end of their savage world, they and numerous other countries adopted Holocaust denial laws. This is exactly how a society moved from one reality to another. This is exactly how a society moved from one reality to another. I don't know why I didn't grasp that when I read it. For indigenous peoples in North America, an important action within the UN human rights framework was the 1987 mandate given to a UN Special Reporter, Miguel Alfonso Martinez, to investigate the status of treaties and agreements between indigenous nations and the original colonial powers and the national governments that now claim authority over indigenous nations by virtue of those treaties. The UN study on treaties completed in 1999 is a useful tool for indigenous peoples in the United States in their continuing struggles for land restoration and sovereignty. The investigation concluded that indigenous treaty rights in the United States have contemporary effective status. The special reporter based this finding largely on the U.S. Constitution, which in Article 6 provides that, and I quote, "All treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding," unquote. Article 1, Section 8 of the Constitution explicitly includes relations with indigenous nations as among the powers of Congress to regulate commerce with foreign nations and among the several states and with the Indian tribes. And let's close the episode there. Hope you enjoyed it. If you did, please do hit that like and subscribe button. And thanks for joining me. See you next episode. Hopefully, maybe. See you there, huh? Alright. Thanks for joining me.